As we're getting the PowerPoint there, I'd like to thank Eide Bailly for having the opportunity to join in and participate today. For those of you that haven't checked, there still is no president that has been elected yet, both from Fox and CNN, so I'm checking both sides there. Also, the regulatory panel that Max mentioned earlier, I thought they had some very, very good comments, so thanks to Eide Bailly for putting on the seminar here. So the first thing here that I think to look at, and my goal here today is to give you an update as to, kind of where we're sitting from a legal perspective with respect to the court system, where we are with respect to farmer lender mediation, where we are with collections. Phil mentioned the non-owned real estate, and I think we have some things just to share here with you from that perspective. First of all, the state of the court. The courts are open. We are still seeing delays, although they are not nearly as bad as they were when we were going through the March to June timeframe of the COVID pandemic. But we still have to expect some delays, and they're on a pretty tight schedule. With respect to what happens, the vast majority of the hearings are telephonic or via Zoom, like we are here today. And by the way, to echo Max, I certainly prefer to be in person so I can share a beer at the end of these things with everybody, but that's not going to happen today. So, but they are Zoom hearings. They are from that perspective. And as a result of that, participants and parties and clients, we have to take a little bit more preparation if we're going to put on evidence in the court. It's not quite as easy as just going in and handing documents to the judge as it was previously. But we are moving forward, and it's good to see along those lines. With respect to the bankruptcy court, bankruptcy courts are going on a case-by-case basis. They have still occasionally had in-person hearings, especially if it's going to be a confirmation hearing or something like that. The first meetings of creditors, which we know is the chance where we get to participate as creditors or as lenders, they're all being held via video and teleconferencing only. The one tip that I can give to you, if you have a customer that does file bankruptcy, that you contact the trustee ahead of time, and there'll be a phone number on the notice, and let them know that you plan to attend. Bankruptcy courts have, as state courts, had evidentiary hearings conducted by phone. We have not had any Zoom hearings yet in bankruptcy court, just telephonic. And again, it takes time for witnesses and exhibits to be exchanged prior to the actual hearing. But what we're seeing is that bankruptcy filings are down by about 50% this year. Obviously, with the COVID and where we're sitting, it's a question of why are they down that low, and can we expect more? And I do believe that we can expect more filings coming up. With respect to Chapter 12 bankruptcy filings, they're down year to date from that perspective. And yesterday, and I apologize, it's not in my PowerPoint, but I had a chance to speak with Mary Nell Preisler, who, as many of us know, is the farmer lender mediation coordinator. And she had shared with me her executive summary information. And in 2019, there were 3,608 notices for farmer lender mediation. In 2020, fiscal year 2020, that dropped to 3,160. So there's been a decline in the number of farmer lender mediations. And you may ask, why is that? Well, if we look at the October 31st article from the Minneapolis Star Tribune that talks about the $40 billion in aid to the farmers, that certainly has a key input as to why some of these are down. One other interesting thing I wanted to share with the lenders here or with the participants is the average age in fiscal year 2020 for the person participating in farmer lender mediation was 60 years old. So the range ranged from 22 to 100, but the average age was 60 years old for the individuals participating in farmer lender mediation. I thought that was just astounding, but it also speaks to the age of the producers that we have sitting out here doing that. The bottom bullet there, increase in Subchapter V cases. In February, right before the pandemic broke, the legislature passed what's a Subchapter V bankruptcy case. It's a subset of Chapter 11, so it's a reorganization for small businesses. And because of some of the issues that that Phil spoke about, and that we are out there, restaurants, unoccupied owner real estate, those type of things. I'm going to go through some of that in a little bit more detail, but that's where we're at from the bankruptcy context. Now I'm going to talk about a couple of collection issues and trends that we've been seeing in our practice. And this first one is marshaling of asset theory. And basically what this is you have a senior creditor who has, let's say, a blanket lien on all personal property, and then also has real estate as additional collateral. And then we run into and bump bellies with a junior creditor who only has a lien on the assets, on the personal property assets. So in my hypothetical here, a secure creditor has $1 million of debt, collateral of $1.5 million for the real estate and $1 million for the personal property. The junior creditor has $500,000 of debt, and then the collateral is the personal property, so $1 million. We've seen in mediations in an outside context where the junior creditor is coming up and saying, okay, senior creditor, you have a blanket on everything, but you're fully secured with just the real estate. So if the borrower debtor files or wants to liquidate, let's say, some personal property, you should let that money come to us, the junior creditor, first, because you're fully secured under my hypothetical on the real estate. We have been able to work these out for the most part, but I just want to make you aware of that. And it's important as we go down here and we ask, and one of our recommendations is to do UCC checks to see if there are any other junior creditors out there who may assert this theory when and if it gets into a collection mode. Another trend we're seeing, and this ties exactly into what Phil was saying with respect to non-owner occupied real estate, is the evictions moratorium. At this point, you can't get an eviction order. You can't have somebody evicted from the property even though they haven't paid. The question here is whether or not the legislature is going to enact or continue through, I guess it was Governor Walz's executive order. How long are they going to allow those evictions protections to remain in place? There are a few limited areas where you can file for an eviction, and those are listed here below. If it seriously endangers the safety of other residents, the lease violations is specific about unlawful actions, if there's significant damage to the property, or in the case of residential, probably the property owner or the owner's family is going to move into that property. So we can go out there, but the ability to remove someone from the property is still putting the enforcement mechanism at bay here with respect to lenders. Further, garnishments are not allowed for consumer debts, but they are allowed for commercial and agricultural debts. Now, I've had calls on both sides. Lenders called up and said, "Hey, do we need to honor this garnishment, or B, can I send the garnishment?" So it's going to be an educational thing on both sides as far as if you want to garnish something, if it's a commercial or ag debt. We've seen that it helps to send some type of a letter with saying this is a commercial ag debt, therefore it's applicable for us to garnish it. And you just need to educate your respective individuals and employees about that garnishment issue. This is one that I've seen more in the past 18 to 24 months than I have seen in my first 25 years of being an attorney here at Gilselson. And this is federal tax liens. They're popping up all over. The one thing to remember in the commercial context with respect to a federal tax lien is that 45 days after the IRS files a tax lien, the bank's lien becomes subordinate to the IRS lien on certain collateral, generally inventory and accounts receivable, after that 45 days. Phil mentioned, having quarterly updates with respect to, balance sheets and that type of information. I think is very important here. And the IRS does not have to give the lender or the bank any type of notice of this lien. So I'd encourage every 30 to 40 days, if you have a suspect or a troubled loan that you think that's really has some issues, to do a federal tax lien, because it could impact their revolving line of credit and inventories with respect to what is actually out there for collateral for the bank. I talked a little bit here about farmland mediations earlier. we had the legislature imposed an extension of the length from 90 to 150 days or December 1, whichever is later. So we're still a bunch of cases will be coming out of farmland mediation on December 1st, 2020. And it's just, again, it depends upon what the legislature is going to do on a go-forward basis, whether or not that's going to remain. As compared to, just like courts, all mediations have been telephonic, which if there was a time to meet somebody for a farmland mediation, it was actually good to sit down sometimes across the table from the borrower, but that has not been able to be done at this point. Foreclosure, this one's coming to an end. Is if you foreclose by action, not by advertisement, but if you foreclose by action, the redemption period had been extended until 60 days after the emergency declaration, or February 15th. So we're getting closer to that time frame, just as a matter of course. The Bankruptcy Subchapter V, again, this became effective in February 2020, and this is for the commercial aspect. I don't anticipate any farmers would use this, given that Chapter 12 has a $10 million debt limitation, and in the Subchapter 5, the total debts cannot exceed more than $2.7 million. Now, that covers a lot of restaurants, bars, that type of stuff out here in greater Minnesota. And for the most part, it may cover, quite a bit in the metro area too, but the debt limitation is $2.7 million. There was an attempt to get it to $7.5 million, but that has not come to fruition yet at this point. And the selection and the whether or not to go with Subchapter 5 is within the discretion of the actual debtor. A couple of highlights about the Subchapter 5. It's cheaper, simpler, and faster than a Chapter 11, which is good for the borrower, and is actually good for the lender because we can get it turned around. We have a chance to present our case to see if it's going to work or it's not going to work. The quarterly U.S. trustees fees are waived. There's a status conference. Judges are taking an active role in the Subchapter 5 cases. And there's also a separate trustee, like a Chapter 12 trustee or a Chapter 13 trustee in consumers. There is a Subchapter 5 trustees, and we have a very good panel of them with a lot of experience who guide and will, try to be the intermediary between the debtor and the creditor. At least that's the ones that I've been working with. They take an active role on that part. As a Chapter 11, if they file a Subchapter 5, the debtor becomes the debtor in possession and retains control of all the assets and the operation. The trustee's primary function, again, is to facilitate as a mediator, and they also have the authority to investigate the debtor's financial affairs. And I think that's important as if we go down this track to see what happened to those loan proceeds where they were drawn on the line of credit, and now there's nothing there. Only the debtor, as a Chapter 12, only the debtor can file a plan of reorganization. It must be filed within 90 days. That's that quick time frame. In a Chapter 11, the debtor has 120 days just to file a disclosure statement, which is not required in a Subchapter 5. So it's on fast track. It's very analogous to a Chapter 12, and it does a nice job of getting things through, at least from what I've seen, on a go-forward basis. There are always, of course, exceptions, and courts will, I presume, grant continuances to file plans longer than 90 days, but it is in there from the statutory perspective. It also, as compared to a Chapter 11, and like a Chapter 12, similar to the debtor's principals can retain ownership of the reorganized debtor if it doesn't discriminate unfairly and is fair and equitable with respect to each class of claims and interest. So that's kind of where we're on that part. No creditors committee. When do they get a discharge? Like a Chapter 12, after they make all the planned payments. So a restaurant could be, bar could be in a Subchapter 5 for 2 years, and then it gets dismissed because it doesn't make the planned payments. There is no discharge that impacted on that part of it. The one point of lenders here is if you see a Subchapter 5, remember that it is a quick process. It's important to look at the bankruptcy schedules to see what they are valuing your assets or your collateral as. And if there's a large discrepancy, you need to be on top of that relatively quick because of the quick time process to get an appraisal and do those items. So very, very important to be on top of these as it goes forward. So Phil mentioned and went over a number of things as far as what we should be doing in this current era. And I think this is true whether it's livestock or a farming operation or a commercial operation, and that's to verify collateral. Um, I just a couple of stories within the past 6 months. There's been 2 or 3 cases that I've been involved with where the livestock in the crop inventory have completely been gone, and they were represented to have, $1 million to $2 million worth of collateral. It is important. We are now, as Phil said, done with harvest basically out here in greater Minnesota. It's time to check that crop inventory, find out where it's being stored, what is being stored, prior to taking those year-end financial statements and seeing, what's going to happen for the 2021 cropping season. So I think it's very important to go out, do verify collateral in a commercial context. Is your equipment there? What's your inventory, and how are those aging receivables listed? Again, a point that Phil made. From the ag perspective, crop insurance, verify the level of coverages, and with all the payments that are coming out, you just need to be reminded that while you may be perfected under the UCC1 financing statement, the only way to ensure that the bank gets the proceeds, at least into its account, is to have a CCC 36 signed for each program. Again, this is the nice thing about working with Phil. I mean, there's a lot of crossover here. It's important from the legal perspective to also verify tax return depreciation schedules, balance sheets, and the actual results. Also, I think it's important at this pre-collection to acquire new information to say, were any new legal entities formed? And I know I've spoke about this before at some Eide Bailly conferences, but individuals are always forming different entities for different purposes, primarily for tax planning. I would say the vast majority of the formation of legal entities and transfer of ownership from Mike Dove individually to Mike Dove Incorporated is not done is done without malice. I don't think there is any real planning for the vast majority. It's for a tax purpose, but it's important that you as the lender find out what those new entities are, so you can acquire an interest or a lien on any new assets that the new entity would have. I also mentioned earlier that it's important, I think, to do a UCC search. We talked about the marshaling of assets, how those are coming out there. And I think that it's just a prudent measure from a due diligence perspective to get that done, to identify other statutory creditors that may be sitting out there along those lines. Another thing that we've seen a lot of individuals who have financed their respective business operations via credit card or via some tech line, that is out there, and they're not afraid to get judgments. So do a judgment search, do a judgment lien search to make sure that your borrower doesn't have any judgments against them. Maybe not so much, it doesn't necessarily impact your collateral position, but it certainly impacts and identifies if there's some weaknesses in areas of cash flow and profitability. Obviously, the one important thing to do is always to do a loan document review. As we talked, is the necessary borrowers and obligors on there, and how does the security agreement match? This is something we've preached about since it changed, but it still pops up once in a while where a UCC is not in the correct name of the debtor based on the driver's license, and they've had to give up their liens if the debtor has filed bankruptcy. I think the example I have coming up here is the fourth bullet down. UCC had Allen, and then but his name on the driver's license was Allen, A-L-L-E-N, spelled a different way. It's important, and I know it's a pain, but you need to make sure that is there, because in the event that they would file bankruptcy, the trustee is going to challenge your security interest if does not match the driver's license. And as Phil said, are you going to decide, are we done? Are we working forward? Are we going to have a workout agreement? We're going to give them another chance, or are we going to cut the string and say, hey, we're not financing anymore. We're done with our process and our procedures. just a couple of collection issues with respect to workout agreements. One, it gives you time to clean up any errors or misdocumentation you have in your file. With respect to not only the perfection, but also with respect to if, the obligors, if some notes weren't signed by everybody that needed to be signed, you have a chance to get that in through a guarantee and or through some amended promissory note to include them as borrowers. Also, you can in the workout say this is your final chance to perform. We have the ability to direct and to push, I guess, a little bit, saying, okay, we're going to give you a chance, but we're going to want something in exchange. And obviously, as we all know, is there additional collateral available, additional guarantors that are available to help secure and tie up that issue. With respect to the final chance to perform, here are just some things. And again, we've talked about them before. There's nothing new here, but they're good reminders to go forward that, if we're going through and we could be in a position to commence the foreclosure of the real estate, but we're going to give this person one last chance to either get refinanced or get back on course, let's ask for a deed in lieu of foreclosure. Let's ask for a confession of judgment along those lines. So in case we end up going to court, we don't have any of those issues to fight about. Another important one has been a stipulation for the replevin of personal property. Okay, whether it's a commercial loan or an ag loan, we're going to give you some time here to succeed. But in the event that, you don't make these payments as we've agreed to in this workout agreement, I might give you 10 days to cure. And if you don't do that, then I'm going to file this stipulation with the appropriate court. And the court's going to issue an order allowing me, the lender, to go out and take your personal property and replevin it. And then finally, in some of the commercial contexts, we could arrange to have the appointment of a receiver placed in that property. So we have the management. We don't have to go through the procedural legal hurdles to get that done. We can do it on an expedited basis. So I think as we go through and as we see some problems, that it's important to keep these in mind, especially if we think it's the last chance. Okay, we've been working with this borrower for 3, 4, 5 years. Really don't want to, but we're still okay, or whatever reason we decide to continue the loan. This is a good method and a good thing to keep in mind with respect to following additional issues. So that pretty much ends my time frame here. Again, I thank Eide Bailly, and Phil and I are available for questions here.
Thanks, Mike and Phil. I'm just kind of looking here too. I don't know that I see any questions out there. So with that, I just want to thank everybody for joining us today. So I think with that, we'll call it a day. Again, thanks, Mike and Phil, and thanks for everybody for joining us, and hope everybody has a great rest of the day.